Hello and welcome to the Legal Concierge Podcast, hosted by Warner Lewis. Warner addresses a wide range of legal questions, situations, and solutions that may apply to you. The information provided in this podcast is for educational purposes only and is not a substitute for legal, financial, or accounting advice of any kind. Warner Lewis is an experienced, trusted resource whose mission is to help you find the answers you need when you're not sure who to turn to. Warner can refer you to a competent lawyer in your area of concern if appropriate. Chat with Warner live every Tuesday on YouTube or Facebook. And now, Warner Lewis, the Legal Concierge.
Hello, everyone, and welcome back to the Legal Concierge Podcast. Great to have you here with us today. Really appreciate it. I think we're coming up on close to our 10th podcast. I haven't counted, but it's coming up on a dozen, which is pretty cool. That's like a milestone for us. Our purpose is to provide information, legal information, broadly to as many people as who desire it, who need it, for the purposes of helping them, one, better understand their options, and two, to get their desires implemented through the form of wills, trusts, powers of attorney, LLCs, corporations, those kinds of legal documents that we help with. The other leg of our practice of the stool is Legal Concierge, which is a boutique a lawyer referral service, which helps individuals and business owners who have legal needs of any kind to pair them, to match them, not just with a lawyer, but with the right lawyer for that particular matter, for their particular matter, at the right cost. We do our best to get our attorneys in the network to engage with clients that we refer to them on a fixed fee basis whenever that's possible. So there are some great advantages and benefits to working with Legal Concierge. Whenever you need a lawyer, let us know and we'll find the right one for you. Okay. So today, before we get started, please like, share, and subscribe. That will help us to grow our channel and get the news and the information out to more people, which we really appreciate your help with. So let us proceed. I've been at this coming up on 30 years. Let's go ahead and put that as big as we can, because this is really the title of our talk today: Estate Planning, Cautionary Tales, and Unintended Consequences. After almost 30 years involved in the estate planning process, first with my family, took about 2.5 or 3 years to settle my father's and my grandfather's estates at the same time. Because everything that could go wrong did go wrong. Okay, let's go ahead and split the screens, Toby. Thank you so much. Over the last 30 years, starting with my family's failed attempts many times to transfer wealth among generations easily and quickly and efficiently, the problems that are possible, the unintended consequences that are common when we plan, but we don't quite think everything through. So we're going to take a look at some of the things that can go wrong. I mean, come on, what can possibly go wrong, right? Pretty much everything and anything, if the estate planning process is not thought through thoroughly and documented properly in order to reflect the exact wishes and desired outcomes that you may have, for example, for your wealth and your family. So that's a really, really important part of the process, to make sure everything is thought through and that nothing slips through the cracks. So what can possibly go wrong? Let's go down the list. First, it starts with people. People are people. We're human. And so it's really all about trust, this whole estate planning thing. You want to name people whom you trust to be in positions of responsibility if you become incapacitated or you pass away. So important. People are people. Some people are better at managing money. Others are better at managing people. Others have the steely kind of character, if you will, to be able to make life and death decisions for a loved one. And again, they may be good at managing money. They may not. They may be better at making healthcare decisions than they are at managing money. So it's all about the people whom we select. And if we select the wrong people, then the chances for unintended consequences and undesirable outcomes can be significant. So geography is also another important consideration. If we're naming our children, for example, to be our successor trustees, and the agents under our powers of attorney, but they live in Singapore, or they live back east, or somewhere remote from where we are. Geography can play a big role in how readily the people that we name to be trustees and agents under our powers of attorney can actually jump in to service and do the job that we've asked them to do. So we need to think about geography. That can backfire. Often closer to us, in closer proximity to where we are, is often better, because the reaction time is much shorter, and therefore can be more responsive to your needs if the need and when the need comes up. Then we talk about people. If you have minor children and you have some wealth that you want to use a trust, for example, to protect that wealth for your minor children. Something happens to you, if our children are minors, we all name guardians in our wills. In other words, who will raise the children in the event something happens to us, the parents. That's really important. Guardianship is really important. But the question is, do we want the guardians, the ones raising the children, the ones who have legal custody over our children, to be the ones who are managing the money for the children as well? And many times we find that in order to avoid conflicts of interest, by putting both of those responsibilities invested in one person, that we name a trustee to manage the money and we name a guardian to raise the children. That way you have a check and balance. The guardians go to the trustee, say, here's our budget, here are our needs, and the trustee has a duty and an obligation to the children to provide for their health, their education, their maintenance, and their support as provided to the children by the guardians. But the trustee is responsible for getting that money to the guardians or making direct payments, for example, to the school that the child will be going to. So there are all kinds of arrangements that can be made for the security of the wealth that's being held and preserved and managed for the children, the minor children, and to avoid conflicts of interest, which is usually always a good thing. So keep that in mind. Thank you for putting my contact information up on the screen. There was a question: what is the role of an executor in estate planning? So that's a great question. There are two roles, basically three roles, okay? There's the successor trustee, the one who will manage the money for the benefit of the beneficiaries. There's the executor of the will, or personal representative of the will. Those two terms are interchangeable: executor and personal representative. Those are that is the individual who stands in probate court in front of the probate judge as the personal representative of the estate of the deceased person. Okay, so that's the role of the executor versus the trustee. And we're going to get into this in a little bit more detail in just a moment, because you actually have two estates. You have your personal estate, everything that's in your name, and then you have your trust estate if you have a trust. So we'll look at that in more detail. And the executor's role is an important one if assets need to be probated, because the executor is in probate court representing one's personal estate. If everything's in the trust and everything avoids probate, that's even better. There are not many circumstances where probate can add value and be of benefit to anyone. One circumstance where probate can be of value is if the person who died owes me money. Then I can show up as a creditor of that person's estate, their personal estate, and make a claim. And then the judge gets to determine whether the claim is rightful or not, and whether I get paid as a creditor or not. So that's a great question. Thank you very much for that. So if you have any questions about this first segment, feel free to call or go online to my calendar at www.calendly.com/Warner-1. You can get right onto my calendar. You can book a 15-minute, 30-minute, even 60-minute consultation, absolutely free of charge. And the purpose of that would be to share your circumstance and your information, your goals, your circumstances, and your desires with me. You either need a lawyer, and we can help to refer you to a lawyer, or you need some basic estate planning or more advanced estate and asset protection planning, some business planning. Those are the things that we can do for you, but there are many areas of the law that we're not competent in, and we can help you by referring you to the right lawyer at the right cost. So don't hesitate if you have any kind of legal need to reach out and contact us. Either call one of the numbers on the screen, jump right onto my calendar, or shoot me an email, warner@lifeplanninginc.com. Okay, thank you very much. So let's talk about what happens when things go wrong, because when you have money and you have people and you put them together, things can often go wrong. And let's jump in. So trustees, these are the people that we name, that we trust to manage the trust estate, all the money and the assets that are in the trust in the event of our incapacity or our death. And so naming the wrong people can be one of the biggest dangers in estate planning. Now, what constitutes naming the wrong people? Well, if you have siblings who are in rivalry with each other, who don't get along well with each other, then you have the potential for a problem. So sometimes we can solve that problem by naming the most steady, if you will, or the least confrontational, the most reliable child first, and then second and third successor alternate trustees, one serving after the other, rather than having them all serve together. So that's one thing to think about. Not just sibling rivalry, but step sibling rivalry, right? Mom and dad, kids with different moms and dads, right? They have different biases, if you will. I'm going to root for my mom in a circumstance, whereas my step brother or sister is going to root for their parent, right? So there can be some real tension there among the trustees, depending on their relationship. Then the question, as we mentioned before, do they serve together, which is potentially problematic, because if you have two, a child from each side of the family, or two brothers and sisters, a brother and sister, or two brothers, two sisters, and they don't agree, having two serving together requires both of their agreement, unless we put a provision in place that lets either one of them have signing authority, which can be problematic as well. One runs down to the bank and does what they think is the right thing, while the other person stands looking on in shock, can't believe that their sibling just did that, supposedly for the benefit of the child. So again, we're balancing this need to name people whom we trust to provide for us, to manage our affairs in the event of our incapacity, and their personalities and the people that we cause them to serve with. So this is really important to think about this. And then beware of favorites. Oftentimes, parents will have a favorite child. In fact, I joke often with clients when I'm asking to list their children, which is usually by birth order. I say, okay, so let's start with your favorite child. What's his or her name? And they all laugh because, oh, we don't have a favorite. Well, really, you do. Most people have a favorite child. But we have to be careful that that favorite child doesn't unduly influence us, okay, set us against their brothers and sisters, put themselves in a seemingly more trustworthy circumstance. I've seen this time and time again, where a child will unduly influence their parent at the expense of the other brothers and sisters. Bad news. And I'm always looking out for these kinds of undue influence circumstances, and I just don't allow it. It's just wrong. Then keeping in mind that trustees have a fiduciary duty to you as the creator of the trust, to the trustor, the creator of the trust. Their only duty is to the person who created the trust and for whom the trust is to benefit, right? So the fiduciary duty is very important. The fiduciary duty is the highest duty that one can be held to when managing money for someone else. So it's a serious duty. And we want to be sure that the people that we put into that fiduciary position, the position of a fiduciary, are trustworthy and have great character and are going to do their job well, okay, and ethically. Then there's a whole area of discretion. In a well-drafted trust, trustees will have discretion over when and how, or whether at all, to make distributions to a particular beneficiary. And we'll look at that in more detail in just a moment. But how wise the trustee is in exercising their discretion when making distributions to a beneficiary who might have who's under age 21, who might have drug abuse or drug addiction problems, those kinds of things. Trustees need to be on top of this to make sure that they're exercising their discretion in an appropriate way. And then a moment ago, when I was mentioning that perhaps two siblings are working together, if both of their signatures are required or both of their approvals are required under the powers of attorney and they disagree, for example, with a medical power of attorney, if the two people who are vested equally in making medical decisions for a parent, for example, can't agree on something, nothing gets done. Doctors will flee. They will run from a circumstance where the agents or the trustees are not in agreement. Okay. So the question is, if you have two trustees serving together, do you want to give either one of them singular signing authority without the approval of the other, or do we require two signatures? Well, any circumstance where two signatures are required, banks go crazy because they don't know if that particular account requires two signatures. They want just one signature to sign a check, for example. They really don't like two or more people having to agree to make a decision to sign a check, for example. So many times banks will force trustees, excuse me, to break that wish where they both serve together and say, no, we're only going to require one signature on an account. So that's something to think about, and things that can go wrong arising from each of these can be problematic. Excuse me. So previously I mentioned that you have two estates. You have a personal estate and you have a trust estate if you have a living trust. The personal estate consists of everything that's titled in your name, your house, bank accounts, your IRAs, your life insurance. It's also known as your probate estate, potentially, because if you own assets in your own personal estate and you die or become incapacitated, you can no longer make decisions with respect to transferring or selling those accounts. You can no longer sign the document needed to do so. So a judge has to supervise the transfer of ownership of assets from the incapacitated person or the deceased person into the name of a personal representative. And now the judge is involved for a 15-month-long average process supervising the transfer of ownership of assets that are stuck in the name of an incapacitated person or a deceased person into the name of the personal representative, and then from the personal representative to the intended beneficiaries. So that's something to think about. You've got two estates. Now, your trust estate is everything that is titled into the name of your trust. So your house is in your personal estate until we create the deed that transfers it over from you as an individual to you as trustee of your trust. Now that house is in your trust estate. I see a question real quick, looks like a great one. Can a trustee remove a beneficiary from a trust? Generally speaking, no, and I can't say this unequivocally. Generally speaking, no, they cannot remove it, but they can change, depending on how the trust is drafted, the beneficial interests in the trust estate or how they are to receive it. So we'll get into those questions of discretionary distributions in just a moment. But a trustee generally cannot. So if you're the original trustor, creator of the trust, and you're the trustee, sure, it's your trust. You can remove anyone that you want. But after you pass or you become incapacitated, the successor trustee has limited powers to make those kinds of decisions. And that's why there are trust protector provisions that we'll talk about in a little bit to broaden the power of the trustee in extraordinary circumstances. Okay, so that was a great question. Thank you very much. The trust estate. Okay, so the trust estate is everything that's titled in the name of the trust. Anything that's in a trust, generally speaking, will avoid probate and will simply pass on to the beneficiaries in a protected manner. And again, beneficiaries will inherit in a protected manner, which means what they inherit cannot be taken from their creditors, judgments, lawsuits, and divorces. The beneficiaries' creditors, judgments, lawsuits, and divorces, if the trust is properly drafted. And we'll talk about that in a little bit more detail in just a moment. So let's talk about funding your trust. Funding your trust is the process of transferring ownership of assets that are in your personal estate over into your trust estate. So for example, once you create a living trust, the next most important thing that you get to do, I would say have to do, must do, if you want the trust to work properly, is to go to your bank. Show them the trust or the certification of trust, establishing that the trust exists and what the name of the trust is, who the beneficiaries, who the trustees are, not the beneficiaries, who the trustees are. And that typically, that certification of trust typically gives the bank or brokerage account or insurance company enough information to affect the change of ownership from that individual to that individual as trustee of their trust. So you got to go into your bank with a certification of trust, sit down with the banker and say, I've created a trust. Here's my trust certification. Go ahead and do your thing. And the banker will go into the computer and they will check the box from personal to trust account and transform basically your personal account into a trust account. And that's when we're changing ownership from an individual to oneself as trustee of one's trust. Now, there are fewer and fewer now financial institutions. Most financial institutions are sophisticated enough to do this kind of internal check the box. It's now a trust account and transform a personal account into a trust account. But there are still some banks who will say, oh, you got to close that bank account, that personal bank account, and open up a new bank account in the name of the trust. Don't do that, because most of us have automatic deposits, automatic payments out of those accounts, and it would be a real hassle to set them up again. In that circumstance, where a bank or a credit union might suggest that you close that account to open up a new one in the name of the trust, don't. Just add the trust as the POD beneficiary, the pay on death beneficiary, or the TOD, transfer on death beneficiary, because that way it has a way to get out of your name upon your death. As soon as you pass away and they show your death certificate, that beneficiary, that transfer or pay on death beneficiary automatically causes that account to be paid over into the trust. So that's one strategy for bank accounts. Real estate, of course, we deed your property, your real estate, into your trust by way of deed, and we mirror that deed. If it starts out life as a warranty deed, we transfer it into the trust as a warranty deed. If it's a special warranty deed, we transfer it over into the trust as a special warranty deed, so as to preserve all of the benefits, the title insurance, and that kind of thing that can go along with a deed that's properly drafted when transferring from an individual to one's trust. So real estate, the deed into trust versus deed into LLC. So if you have a rental property and you choose to keep that rental property in your own name, that's fine. That rental property can be in your trust and you can operate it as an asset of the trust. Put all of the revenues and the expenses through the trust if you choose to, but then if somebody slips and falls on that property and they sue the owner of the property, in other words, they sue you and your trust, in theory, they could get everything that's in the trust. And this is why people create LLCs owned by their trust so that the LLC avoids probate, but the LLC is designed to limit one's personal liability to the asset that's in the trust. So we'll talk, in fact, up on YouTube, you'll find a number of segments of our podcast that deal with LLCs. We'll touch on them a little bit more in just a moment. IRAs are really important to make sure that IRAs are pointed by beneficiary designation to the one that you want to receive them. So it could be your spouse, it could be your children, your spouse, then your children. But excuse me, naming a spouse as the primary beneficiary of an IRA is usually a really great idea. The spousal rollover IRA is the most elegant way to transfer investment or retirement monies, I should say, to the surviving spouse. But the inherited IRA, the IRA that transfers from the parent to the children, is no longer protected from creditors under federal law. So we create trusts nowadays that are designed to receive IRA and 401k retirement plan distributions and protect the after-tax proceeds of that IRA for future generations. So it's very important when you're talking about IRAs that those be funded properly. Life insurance is the same thing. So let's say you have life insurance and you've named your spouse as the beneficiary. Okay, so your wife is driving home from your funeral and injures someone in a car accident and gets sued. Now, because of the beneficiary designation naming her personally as the beneficiary, that money could be taken from her in a lawsuit. But if one names the living trust as the beneficiary of life insurance, upon the first death, that trust becomes partially irrevocable. Irrevocable trusts do a great job of protecting assets. So it might be a really great idea to name the trust as the beneficiary of your life insurance for that asset protection that the trust can provide upon death. Then you talk about personal possessions, clothing, furniture, jewelry, Bitcoin, bowling balls, all of that stuff we transfer into the trust, typically using one document, that assignment of tangible property document, assigning all of your stuff into the trust. So it's important that gets swept into the trust. And then firearms. A lot of us don't have weapons. A lot of us do. A lot of us have a lot of weapons. So if it's just a few, that's fine. It's all included as part of your personal property. But if one were to have dozens of weapons, it might make sense to create an NFA firearms trust, a trust specifically designed to be the recipient, the owner of firearms, in order to avoid probate, first of all, and to avoid problems of, gee, your spouse shows up at a gun show with 25 guns to sell without a dealer's license and a firearms dealer's license. There could be problems there. So welcome to the world of unintended consequences and how proper planning can really help to ensure great outcomes. Okay, let's talk about the distribution of that. Now we've gotten everything into the trust, okay? What happens when we pass? When we pass, the trustee gathers everything together, does the accounting, presents to each of the beneficiaries what their share will be. Everybody signs off and says, great. And then they begin to receive their inheritance. We look at age or ages of distribution. So it's not uncommon anymore to see the earliest ages of distribution starting at 25, not at 21, not at 18. Because if a beneficiary only has to wait until 18 to receive $1 million or even $100,000, they may face a difficult decision. Gee, college education or red Ferrari. Okay, we don't want them to have that kind of a decision that early on. So the trustee holds back, depending on the terms of the trust, that money up until, let's say, the age of 25. That age of 25 lets a beneficiary get through college, get a couple of years working under their belt, learning the value of a buck, and so they can hopefully be better prepared from life experience to receive a significant amount of money. But up until the age of 25, for example, the trustee owes a fiduciary duty to the beneficiary, where they must make money available to a beneficiary for their health, education, their maintenance, and their support. HEMS, health, education, maintenance, and support. That is a standard that every fiduciary, every trustee is held to when managing money for someone else. So then the other question is, does the trust distribute outright and free of trust into the name of the beneficiary, or does the trust hold back in further trust for the benefit of the beneficiary? So what's the difference in outcome? If the trust distributes outright and free of trust into the name of the beneficiary, and that beneficiary gets sued, a judgment entered against them, lawsuits, or divorce, that money can be taken from them because it's in their own name. But if it's in an irrevocable trust for their benefit, it cannot be taken from them if it's well constructed and well drafted. So that's a big question. Do the children get it outright and free of trust in their names, or do they receive it in a protective further trust? Then there's also an opportunity to, let's say a child is a minor now, but one day the outright age of distribution is 25. But there's the possibility of naming the beneficiary, the child, as a co-trustee with, say, your brother to learn the ropes for a couple of years before they're actually given the keys to the kingdom. So one can do that. They can become a co-trustee at the age of 23, and then the sole trustee at 25, or any age that you deem appropriate. Now, real estate, upon your passing, your children will inherit a house, perhaps several houses. And the question for them will be, gee, do we sell it or do we rent it out and divide the rents? That's a big question. And if your children decide to keep the house, then they'll want to think about putting it into an LLC if they're going to rent it. That LLC will receive all the rents, pay all the expenses, and then divide up the gain, right? The profit from that month's rentals to the beneficiaries. Then let's look at IRAs. The rules around IRAs have changed significantly. Really, really important to make sure that the beneficiary designations on your IRAs are done appropriately, and ideally in a living trust that is well featured, that is well documented, to allow the trust to be a qualified beneficiary of your retirement plan money and to protect it for future generations. That's the trick. And then finally, life insurance. Again, the same thing. If one were to name one's spouse, I'm going to go ahead and get to that question in just a moment. If one were to name one's spouse by name as the beneficiary, and your spouse drives home from your funeral and injures someone in a car accident, because that death benefit is in her name, it can be taken from her like that. But if the trust is the beneficiary and the trust is properly drafted, then that death benefit can be outside of the reach of creditors, judgments, lawsuits, divorces, all of that. Okay, what are the benefits of a skip trust? And I think we're referring to a generation skipping trust. So if one has lots of money, so first of all, the threshold for death taxes is $23.4 million for a couple. That's most people don't have that kind of money. That amount of money for a married couple is exempt from death taxes, $23.4 million. Anything over that, one could take advantage of a generation skip where they get a credit. I think it's $1 million, perhaps a bit more. It goes up every year. And honestly, I don't do a lot of generation skipping trusts, but essentially it's an opportunity to shelter just a little bit more from death taxes by skipping a generation and letting it go to grandchildren rather than children. So there are all kinds of strategies to help mitigate the effects of taxation, but the threshold for taxation on inherited money is quite high, $11.7 million per person. So how long does a trustee have to distribute assets? Well, it depends on the trust. Our trusts say that a trustee has 6 months before they need to start thinking about making distributions. But that wouldn't stop someone coming in. It's designed to stop someone from coming knocking on the door of the trustee 4 days after your funeral and saying, "Where's my money?" So in our trust, we say 6 months to do the accounting and let the dust settle, pay the debts, pay the taxes, do all those things before being expected to start thinking about making distributions. That'll help keep people who want their money right away at bay a little bit, and that can be helpful. Any other questions? Let's see. Benefits of a skip. Okay. How long? Okay. So any questions about any of this, feel free to contact us for an absolutely free consultation. When I say free, I mean free, no cost. And whatever information we provide you during that no cost, no obligation meeting is yours to use however you want. You can go on down the road with that information and use it however you wish. Of course, we'd love to earn your business, but you have no cost or no obligation when you schedule time with us. So you can go online to my calendar at calendly.com/Warner-1, book yourself 15 minutes or 30 minutes, and we'll chat about your circumstance, answer all your questions, review all your documents, and see what your best options look like. Okay, great. All right, now we're going to look at the issue, at the topic of medical issues. First, they say that 60% of us will go through some form of incapacity before we die. That's 6 in 10, okay? So chances are we may have some requirement for long-term care or something like that in the course of our lifetimes. Well, if one is only temporarily incapacitated, our powers of attorney say if you regain your capacity, no one can stop you from coming back and being your own person. But what happens if you become incapacitated and then you regain capacity and your agent under the financial or the medical power of attorney isn't letting go? They're not giving it back to you. You have to take your agent, your child, or your spouse or your loved one to court to get them to loosen the grip. No, it's better to have a power of attorney document that takes that into account and says if you're incapacitated but later you regain capacity, you can become your own person again. Now, in the event of permanent incapacity, we have an issue, a financial issue involving how to pay for long-term care. Long-term care is very expensive. I think it's upwards of $75,000 per person per year. And there are some creative and effective ways to plan for long-term care insurance, but not all long-term care strategies are the same. So I urge you to contact us. We can talk about how to provide a pool of money to cover your long-term care needs if you need it, but that you can benefit from if you never have long-term care. You can use it in other ways, and your children can inherit that bucket of money as well. Unlike old school long-term care policies that if you don't use them, you'd lose them. So that whole long-term care model is pretty much dead from years ago. And there are some great, effective, creative ways, effective ways to provide for long-term care in the event you should become incapacitated. Medical treatment. Okay, so our living will and powers of attorney let us say hey, if I'm terminal, don't keep jumpstarting me. Don't keep feeding me intravenously. Don't intubate me and force me to breathe. Let me go. Okay, so it's really important to have these documents in place. If you don't have these documents in place, then your family doesn't have the legal standing to tell a doctor, okay, pull the tube out, stop intubating them, quit feeding them, those kinds of things, because the doctors don't know what your wishes are. They're relying on your children. It can be problematic. So you really, truly, you don't want to become incapacitated or die without the right documents in place. Having the right powers of attorney and other documents like trust, extremely important. Look at life support. You want to be sure that your documents say, hey, if I'm terminal, permanently vegetative, or comatose, I want you to remove all life support and let me go. Then the thing is, again, about people, if you have the wrong person as your medical agent and they're squeamish, they're reluctant, they refuse to pull the plug on mom or dad, you have a problem. And that's not all that uncommon, where a child is like, I can't pull the plug. I'd be killing mom or I'd be killing dad. What an awful idea. What an awful thought. But the truth is, excuse me, that your living will and your powers of attorney allow you to say, hey, if I'm in this circumstance, I do or don't want tube feeding, do or don't want life support, do or don't want electric shock. So very, very important documents. And then finally, the final arrangements. These are your burial or your cremation instructions. Now in Arizona, from what I understand from people in the mortuary business, that if you elect cremation, a mortuary is supposed to, if you haven't made those arrangements in advance, the mortuary is supposed to get the consent of all of your children or your spouse. But typically the children all have to agree to cremation. Otherwise, the default is burial. So that's why it is so valuable for us as we age in life, as we get into our 70s and 80s, to think about pre-purchasing those arrangements. Because if cremation arrangements are purchased in advance and paid for in advance, the children have no say. You've voted, and you voted with your dollars, and that's the way it's going to be. But if you just write on a piece of paper, hey, I want to be cremated, not buried, they have to check with your children typically. So there are some ins and outs that we really need to pay attention to. Most of us would probably never think about how the right way to put our final arrangements into effect would be, and that's to put them in writing. Okay, any questions about all of this? Give a call, free consultation, no cost or obligation. I will be delighted to chat with you on any legal concern that you might have, someone that you know might have a family member. And if we can't help by preparing wills and trusts, LLCs and corporations for you, there's so many different other areas of the law that we're not engaged in, we're not competent to engage in. We can introduce you to the right lawyer at the right price. So please just remember that we have a great lawyer matching service for individuals and for business owners that doesn't cost a penny to you. Okay, great. So now let's look at what happens if the kiddos decide they don't agree with your wishes. What if there's a contest against your will or a contest against your trust? Oh my gosh, talk about a way to slow down, to drag down the process of settling your estate. Okay. One of your children, maybe more than one of your children, feel like they've been promised something in the past that they're not getting, or that they're entitled to receive something that they're not getting. Now they make a stink. And they may even run into a lawyer at a cocktail party who says, I'll take care of it for you. We'll go ahead and file a claim in probate court, and we'll see if we can't get you satisfaction. So this is where the process really starts to go off the rails. It becomes an out of control process, trying to settle your estate without documents like trusts and wills with no contest provision. So contesting your will and trust. Whenever there's a disagreement, there's going to be delays. It's expensive, very possibly broken relationships as well. In our documentation, we say that if there is a contest, first of all, there's a no contest provision, which we'll get to in a moment. But if there is a disagreement, most well-drafted trusts will say arbitration as opposed to lawsuit. Okay, that gives everyone an opportunity to be heard by an arbitrator. It's less expensive, it's more quick, and the decision of the arbitrator is binding. That's a great way to settle, but you have to put it in writing that arbitration is the first course of action in the event of a disagreement. Then there are circumstances where what you have written in your will and your trust are disregarded. I heard a story yesterday from a client who said that after a second marriage and all that, an uncle of the surviving spouse, the uncle, actually both spouses deceased, the uncle who was named as executor, all of a sudden the will disappeared. There is no will. And so now all of a sudden everything changes. And this can be obviously a real problem where someone intentionally destroys or hides a document. See it pretty commonly, actually, unfortunately. One of the things that we do to combat that is after we sign wills, trusts, powers of attorney, we scan everything into PDF files. So we have PDF soft copies, digital copies of all of the signed documents, so that if something gets lost, well, we can find a replacement for it. And I think that's a really valuable service. You want to be sure to have soft copies of all your documents as well. And then, of course, the no contest provision itself in any well-drafted will or trust says, hey, if you do anything, any of these 5 or 10 things, by trying to invalidate the will or the trust in a court of law, try to overturn it or do anything like that, that you're automatically disinherited. In fact, they will treat you from that point as if you had predeceased the client, that you had predeceased the person who has the will or the trust. So completely disinherited. And that no contest provision, in my experience, has slowed down or stopped many a disgruntled beneficiary in their tracks. Trustee just says, here's Article 10 of your mom or dad's trust or will. If you do this, you're out. So save yourself the time and money. Okay, so that's one way to get around contests, expensive, long, drawn-out legal affairs. So any questions about all this, feel free to call. Get yourself on my calendar through calendly.com. We'll have a 15-minute conversation, half an hour, even longer if you need it, and we'll sort out your problem. If we can't help you, we'll find a lawyer who can, okay? Thanks. All right, let's talk a bit about protecting your assets now. As individuals, husbands and wives walking around, we have no creditor protection at all, okay? Everything's either in our names, which means if something happens, they can take it from us because it's in our name, or it's in a revocable living trust, which is the same as if it was in our names, because you as an individual, here, let me get my fingers here, you as an individual and you as trustee of your trust are one and the same person. There's no distinction. There's no difference between you and you as trustee of your trust. And husband and wife are also one and the same person, unless we do a contemporaneous property agreement and agree to split, to sever community property, turning community property into equally owned 50-50 separate property. But that's something that you have to do consciously and deliberately, documented legally in order to accomplish. Otherwise, for the most part, none of us has asset protection unless we create an irrevocable trust and we give away our money. But who among us is prepared to give away all of our money? We're still living. We still need it. We still want it, right? So it's very difficult to overcome the irony that the best way to protect your assets while you're alive is to give them away. Well, most of us can't do that. And there are ways, though, that husbands and wives can work together to protect assets and other structures that can help to do that as well. So all hope is not lost, but it's very difficult to protect one's assets during their lifetime, during our lifetime. So with a trust, trusts distribute assets 2 different ways. One, either outright and free of trust into the name of the beneficiary, which means that it's subject and open to their creditors, judgments, lawsuits, and divorces because it's in their name. The other way to distribute assets is by holding those assets in further trust, in a trust that becomes irrevocable by virtue of the trust owner's death. Trusts are revocable during lifetime. They become irrevocable upon death. While you're alive, revocable trusts do not protect assets. When you die, irrevocable trusts do protect assets. Problem is, most trusts distribute outright and free of trust, so they lose all of that asset protection that's possible to achieve in a living trust that becomes protective upon the owner's death. So in an irrevocable trust, assets remain in the protective trust. The beneficiary becomes the trustee of their protective subtrust. If trouble came up, so let's say I inherit in a protective subtrust and I get divorced or I get sued, I can step aside as trustee of my protective trust and appoint a trust protector or a special independent trustee, typically a high-powered lawyer, who would defend my trust against all claims And then once those claims had passed and been settled, hand the keys back to me and wish me a nice life. So trust protectors can defend trust assets in those kind of sticky situations where one might be sued or in the midst of a divorce. So very important to review your own trust to make sure that it has in further trust provisions, that your trust has protective trust provisions. And also it's important that your parents' trusts have protective provisions for you so that when they pass, what you inherit from them, you can't lose to creditors, judgments, lawsuits, divorces. So keep that in mind. If you have children and you have parents living, you are the sandwich generation. There's a fun podcast on the sandwich generation. You should check that out too. A number of circumstances unique to you if you have children and parents alive at the same time. So keep that in mind. You have your children to plan for, and you want to mind how your parents have planned for you as well, because you're going to have to deal with it when they're gone. Okay. Super. Any questions about this? Feel free to contact us. Always happy to provide you with a free consultation, no matter what the circumstance are. If we can't help you, then we'll connect you with a lawyer who can. Okay, great. Thank you. How long do we have to contest a will? So upon our death, typically probate is started, the will gets probated, and that window, the creditor's window, is open for 4 months. And that's a 4-month window in which a creditor, like a tradesman who did some work but never got paid, could come and make a claim against the estate, against that person. After that creditor window closes, in theory, that creditor's access to be able to make a claim against an estate falls away. So that's pretty much from the start of probate, or one can cause probate if one's a creditor too. Keep that in mind. If one has a valid interest, one could, in theory, open up a probate against someone's estate and make a claim. But after 4 months, all bets are off. That's pretty much it. Any of my attorney friends who are out there watching, and if I've made an error, if my knowledge is not as good, please call me or email me and educate me, okay? But that's my understanding after all these years as to how that creditor window works, opens and closes. Thanks. Okay, let's talk a little bit about LLCs and asset protection. What can go wrong there? Well, here's the basic probate avoidance structure for one's assets. So specifically, you see in the green structure there, the revocable living trust, which owns your house, your bank accounts, your brokerage accounts, personal possessions, and your business interests. Those business interests might be in the form of your operating company, LLC or corporation, or rental properties that are owned in your LLC, or partnerships that you have with other business owners, other people that you trust and that you're in business with. And certain other investments can be held in LLCs as well. So the beautiful thing about this structure is that with your company, LLC, or your rental properties, for example, your personal liability is limited to what's in that LLC. So if someone slips and falls on your rental property and they sue the owner of the property, first of all, they're not suing you or your trust. They're suing the LLC, which is owned and controlled by your trust, so it avoids probate. But they sue the LLC, not you personally. Your personal liability, if the LLC is properly documented and all the boxes are checked, then your liability will be limited in theory to what's in the LLC. They can't jump over the wall of the LLC and get to everything else that you own. So properly drafted LLCs provide great internal liability protection. But this structure does not protect you from external liability. So let's say one were to injure someone in a car accident and get sued. They sue the owner of the car, that's me, and they can get to me through my trust, which is the same as me, and get to everything that I own underneath my trust. Okay, the LLCs, even though the LLCs are internally protective, they're not externally protective. They're not protected from external liability. There are other techniques that we can use to help to mitigate the potential for liability from external liability, like a car accident or something like that. It's a bit more complex, and there are up on YouTube Multipli owned LLC podcasts that will deal with that more complex asset protection structure. So feel free to go check that out. Okay. So here's the thing about multiply owned LLCs. Multiply owned LLCs have more than one owner, more than one member. and they are subject to the new LLC law. Every Multipli owned LLC in the state of Arizona since September of 2020 must have an ALCA, an Arizona Limited Liability Company Act compliant operating agreement. Before, it used to say, oh, you may or may not have an operating agreement. But the current law, if you have more than one owner, you must have an operating agreement that spells out certain terms and provisions. Now, there are some drawbacks to the default Multipli owned LLC operating agreement. But it's possible, fortunately, to draft around those most onerous problems. So again, if you have questions about that, go up to the to YouTube and check out the multi-member LLC podcast. That'll give you all that information. So there are asset protection benefits to Multipli owned LLCs, specifically because an LLC has more than one member. If one of the two members gets in a car accident and gets sued, they can't, it's much harder, I can't say never, but it's much harder to get a judgment or a charging order to stick against an individual who is one of many owners of an LLC, because it wouldn't just be harming me, getting restitution from me, it would be harming the other owners, which is not fair to them. So a multi-member, Multipli owned LLC can provide great sort of organic asset protection because it's owned by more than one person. Harder to get a charging order or a judgment. And those ownership interests, if I may, whatever, if you own all of your LLC or if you own a portion of it, a percentage of it, what you own should be, and that sounds like advice, most people, I'll take that back, most people put their ownership interests in LLCs in their living trusts so that they avoid probate. It's very important to do that. Many, many people have their own LLCs in their own name. What happens when they die, that LLC and all that goes with the LLC goes through probate along with everything else. So that can be easily avoided by naming the member, naming the trust as the member or the owner of the LLC. And then if one is a partner with someone else in an LLC or a corporation, what if one of the partners dies? Does their spouse or do their children become your partners in the business? That can be problematic for many business owners. They don't want to be partners with your spouse or with your children. So what many astute business owners do is they put together a buy-sell agreement that says if one owner dies, there's life insurance to pay their estate the value of their shares, of their ownership interest in the LLC or the corporation. So their estate gets the money and the surviving partner gets the shares, gets the rest of the company. So a buy-sell agreement can be a very effective tool pre-arranging a sale and purchase of stock or LLC interests in the event of the death or some other circumstance of one of the owners. That can make that whole situation easy. Now, what you don't want is to be a part owner of an LLC where the other owners own their interests in their own names. Let's say I have a business with 3 other people, there are 4 of us, and each one of us owns our 25% in the LLC in our own name. One of them dies, their 25% is going through probate. The next one dies, their 25% goes through probate, and on down the line. It's a mess. So there are unintended consequences of multi-member ownership of LLCs that can easily be addressed. But you got to talk to somebody who knows what they're doing, who can walk you through each of the potential unintended outcomes and make sure that they're all addressed. Okay, awesome. So if you have any questions about any of this, feel free to give a call or to get on my calendar. I'd be happy to chat with you for 15 minutes, a half an hour, more if you'd like. If it's an area that we can help you with, like estate planning, business planning, asset protection planning, happy to help you. If we can't, we'll match you and your particular unique legal need with the right lawyer at the right cost. Okay, so don't forget that's a really valuable service that we provide that costs you nothing. Okay, great. All right, here's some final thoughts. We're coming up on an hour. Somehow I always seem to make these last an hour or so. And so some final thoughts. First, let me encourage you to schedule a free consultation. It doesn't cost you anything but a few minutes of your time. Have a conversation with someone who knows what they're doing in this area and can provide you with some useful information and answers to your questions. We can review all of your existing documents and tell you what you have and what you don't have and what you might do to upgrade or fill in the gaps. to think through all the options, help you identify the right people to serve in the right roles. Because remember, they may be really good at business, but they may be squeamish about pulling the plug. So you want to put one person as your agent under the financial power of attorney, but not under your healthcare power of attorney. Okay, you want to make sure that the people that you trust are able and willing to take care of business for you. Then if it's appropriate, we can update and amend, revise all of your documents as appropriate. And if we can't serve you, if you need a lawyer, that's where we'll refer you to the best, and that referral service costs you nothing. Okay, so this is what I have for you today, dear friends. Thank you so much for joining us today. Really appreciate your time and interest. We will be back next week with another rousing topic. Let's see, there are a couple of questions. Let's see here. What documents are needed for estate planning? Okay, so for that, I'm going to send you to YouTube, and you can look for the podcast that talks about, in addition to a trust, what other documents do I need? And there is a long list. So that's a great question that I can't answer here right now, but please go to YouTube and look up that podcast. Okay, terrific. Hey, thank you very much. Appreciate your participation, and we'll see you next time. God bless. Bye-bye.
Thank you for joining the Legal Concierge Podcast, hosted by Warner Lewis. Kindly hit the subscribe button below and leave a comment or question regarding your particular legal situation. Feel free to submit ideas for future shows as well. We appreciate your sharing this podcast with family and friends so they can find answers and solutions to their legal situation as well. Check the notes below for links to valuable resources. See you again next week.